Share screen. All right, this week we're looking at the Acts Interpretation Acts, and we're focusing obviously on the Queensland legislation and the Commonwealth legislation, but each of the states and territories have legislation as to the interpretation of statutes and statutory instruments, and it's generally quite similar across the different Australian jurisdictions. Since 1901, there's been an Acts Interpretation Act Commonwealth, and it was amended recently in 2011, particularly as to Section 15AA, which is the purpose section, which we'll come back to. But and we also look at this concept that the legislation is superior to the common law or to case law, and because of Parliament's sovereignty. We're going to look obviously at this specific interpretation legislation at the state and Commonwealth level, focus on a number of specific phrases and concepts that the legislation looks at, and then we'll touch upon how the courts then use this legislative interpretation legislation to assist them with solving specific factual and legal problems. We looked at last week and made mention of the Legislative Standards Act. We were looking at it last week in the context of Parliament directing how legislation is to be drafted and how it's then to be passed through the Parliament, and that is obviously borne out by the Legislative Standards Act 1992. And we also looked last week at the Queensland Office of Parliamentary Counsel website. Which is here. And when I click on A, it brings up the Acts Interpretation Act. Let's look then at some of these key terms. Ambulatory operation. This is the concept or the idea that even though there are changes in legislation, it can be inferred that a reference to an act means the same act as amended from time to time. It's very rare now that this is the case. I think it's the exception rather than the rule, at least in Queensland. That is, when they change fundamentally an act, they will tend to go and change the acts, at least to the extent that they mention that act. So one act is changed, they'll then go and change other acts to pick up those changes in name or specifics to the extent that it's required. So I think it's important to be aware of the phrase, but also to double check that is the case. So, for example, when the Trade Practices Act in the Commonwealth sphere was changed in 2010, if my recollection serves me correct, to the Competition and Consumer Act, a lot of other pieces of legislation referred to the Trade Practices Act. Extrinsic materials, I think 2 weeks ago we looked very briefly at the Queensland Parliament website, because on there you can find the Hansard, which is where the second reading speeches can be found as to specific pieces of legislation. Often now there are explanatory memoranda or memorandums as to a specific act which assist us in interpreting what an act will mean. And then, of course, we can use general information like dictionaries. You might recall that last week I mentioned that I had a matter which went over 4 days in the federal court, where we were focusing on the meaning of the word organise in relation to a Fair Work Act matter, an industrial dispute. So generic provisions, that's where the Acts Interpretation Act or Acts are very, very helpful, because they allow us to identify the meaning of generic provisions, commonly used provisions such as a calendar year or a month or a day, a period of time. If it's expressed in an act, what does that mean? We mentioned before this concept of parliamentary sovereignty. That is, that where judges have interpreted pieces of legislation, if the Parliament, for example, changed the Acts Interpretation Act, that would override the common law, the judge-made law, interpretation of a specific section or sections, for example. Severability, that's really a phrase that you see commonly in the context of contract law, where you can exclude a part of a contract to sever it, leaving the remainder of the document intact and enforceable. Ultra vires is a Latin phrase that refers to a decision beyond power. Often this is an administrative law concept whereby the courts are examining the act, let's say, of a department being a part of the executive, and the courts are asking whether the department has acted beyond the power or the scope set out in that legislation that is relevant. Under this heading legislation, we're looking at the different acts, and that is acts as to interpretation in the different jurisdictions. And our focus is on the Acts Interpretation Act Commonwealth, and I'll just bring that up through ComLaw. And we're also looking at the Queensland Acts Interpretation Act 1954. It's obviously very important that you can find those acts, not only that you can find them, but that you can find the act that was relevant at the specific point in time. So if the material facts in issue, the facts in issue were facts which occurred on the 7th of August 2012, what was the version of the act, say in Queensland, that was applicable on that day, at that point in time, and was it any, because it may be different to the act which is in play today. And then, of course, to look to see whether judges have interpreted the section that you're relying upon in that act, and to look at that legislation and interpret it as well, and then to apply it to the specific facts in issue. You'll see a reference here to the Commonwealth Acts Interpretation Act, Section 46, as to the construction of instruments. If a provision confers the power to make an instrument that is neither a legislative instrument nor a rule of court, then the Commonwealth Acts Interpretation Act applies. So you can see there's a number of steps that have to be crossed there. You have to get a hold of the relevant instrument, to check to see whether it's an instrument for the purposes of the Legislative Instruments Act, which means you'd have to look at the Legislative Instruments Act. Then to see whether it's a rule of court, which requires, for example, you might a recognition, let's say, of the Federal Court Rules 2011. And if neither of the Legislative Instruments Act nor the Rules of Court apply, then the Commonwealth Acts Interpretation Act applies. So even though that's one section in the Commonwealth Acts Interpretation Act, it's quite it's a stepping stone approach that then needs to occur. And obviously to do that requires an assessment of each of those things: the original instrument, then the Legislative Instruments Act 2003, then the Rules of Court, and then returning back to the Commonwealth Acts Interpretation Act. There is a specific, in this, at the bottom here, it's referring to the fact that in Queensland, the position once again is different from the position in the Commonwealth. That is, there is a specific schedule in the Queensland Statutory Instruments Act 1992, which lists the provisions of the Queensland Acts Interpretation Act, which are applied to statutory instruments. I'll give you an example of this in a practical context. Last week, on Tuesday, I had a matter at QCAT, and the matter was about a directions to rectify which had been made by a government body, the Queensland Building Services Authority, against the building company that I was acting for. And the question at QCAT was whether a statutory instrument, the extent of the applicability. The statutory instrument was the QBSA defects policy. It was called something like that. Might have been, and of course, it also was described as the defects guidelines. There were a number of pieces of legislation which were applicable, and there was also this policy or this statutory instrument which had been gazetted in the Queensland Government Gazette, the place where the government advertises that things have some type of authority. And so there was this interplay between the Acts Interpretation Act, the Statutory Instruments Act, the fact that the document had been gazetted, and also that document, of course, over time had been changed. And so we were looking at all those things in the context of that matter. It's not something to worry about, it's more just an example of this last section on this page. And here's this schedule, which is in the Statutory Instruments Act, but which says provisions of the Acts Interpretation Act that apply to statutory instruments. And there it is, the listing there. So now we're going to start to look at this concept of application. That is, application of the Acts Interpretation Acts, or the Act in question, to specific circumstances. Now, obviously, the Act is very helpful in that it defines certain generic terms which can be used and imported or applied, to use the heading, into other legislation. Sometimes the legislation that you're specifically looking at will have its own definitions, and there can be a little interplay between the two. But the general rule is the specific will override the general being the Acts Interpretation Act, and in that case, specific definitions in a specific act. We're going to look at some examples below: gender, age, numbers, distance, and time. And you can see how they would have very far-reaching impacts across a whole range of legislation. So this is something, you don't just see this in statutory materials, you'll see this in contracts that are drafted. That is that when you see, for example, a conveyance document as to land, a contract as to the sale of land in Queensland, there are standard terms, standard conditions which are applicable to the contract and which are reproduced time and time again. And I think the Real Estate Institute of Queensland published those standard terms. And that sort of, they talk about the boilerplate contract, has those standardisation of terms. The interpretation legislation assists the court or the courts in how they will interpret legislation. It's a direction, effectively, from Parliament to the courts as to how legislation will be interpreted. Rather than just saying, what does the sentence mean, the Parliament itself is telling the courts how they should interpret it. I think the greatest example of this that I'm always confronted with is in the taxation context. Up until the purpose rule was added to the Acts Interpretation Act, when a tax matter came before, let's say, the High Court of Australia, the High Court was confronted with the taxpayer and the tax office on the two sides in an adversarial scenario. Where the High Court was interpreting a specific piece of legislation, the High Court was looking at that legislation, and where there was uncertainty, the court would tend generally to favour the taxpayer. But when the purpose rule, the purpose of the legislation is looked at, and when the Parliament is saying to the court, you must apply the purpose of the legislation, well, the purpose of tax assessment acts is to assess tax for the purpose of the payment of tax to the tax office. And so the court now, in interpreting the difference between the taxpayer and the tax office, when they're looking at the purpose as dictated to them by the Acts Interpretation Act, now says, well, the purpose of the legislation is to pay tax in an underlying object sense. And now we're going, if there's uncertainty, we're going to favour the tax office. So the practical impact of the Acts Interpretation Acts has been quite significant. All right, so let's start having a look at some of these generic provisions. There are a number of these, obviously, and we're just going to focus upon some of them, but they're quite helpful. So gender's the first one. Gender-neutral language can be taken or may be taken for granted, but interpretation legislation avoids any uncertainty by saying one gender includes every other gender. Now, obviously, most documents we see now will be neutral in their gender makeup. An act which uses, for example, he would not normally be applied to another situation, but so males, a male or a he includes every other gender. In an act, words indicating a gender include each other gender. So that's section 32B. So you can see it's been added in over time, and rather than change all the numbering and all the other sections, they've added in the capital B, so they've added in 32 capital B. Age. Unless the contrary intention appears, the time at which a person attains a particular age, expressed in years, is the commencement of the relevant anniversary of the date of the birth of that person. That is just after midnight on your birthday. So a number, even that, you can see even that age section requires a careful factual consideration of a specific set of circumstances. A number, so section 32C, in an act, words in the singular include the plural and words in the plural include the singular. So you can see how that might have an impact over time in specific circumstances. Distance. Normally distance is measured in a straight line, but in Queensland, measurement of distance in applying an act, distance is to be measured along the shortest road ordinarily used for travelling, unless there is a contrary intention that distance is to be measured in a straight line or on a horizontal plane or in another way. I suppose it's easier now in the context that we can use things like Google Maps to identify the distance by road, but even that would require a factual finding in the sense that distance is to be measured along the shortest road, so there needs to be some interpretation of what the shortest road might be. In the Commonwealth legislation at section 35, and you can see the sections have some similarity in terms of their numbering, In the measurement of any distance for the purpose of any act, the distance shall be measured in a straight line on a horizontal plane. Very difficult, I would have thought, to measure on a horizontal plane, only in the sense that the Earth is not flat. But we'll leave that to another question for another day. Time. The time of day means the standard or legal time in the place where the legislation applies. So for a day, it's 24 hours commencing at midnight. For a month, it means a calendar month, obviously under the Gregorian calendar, which is what we use, of course. Public holidays. In Queensland now, there is the, I'll just try and bring it up if we can. Well, there is the Attorney General's promulgation by Gazette of what are the public holidays, and I think it lists them for the next 5 years. And I've had cause to check that a few times, only a sense that you're putting things in the diary for personal reasons, quite apart for work reasons. But it's quite helpful because, for example, in another part of the state, let's say, use the example of Rockhampton, where CQU, of course, is based, there will be a specific holiday in that place, but there'll be a different holiday in Brisbane. So it's worth checking those. Time can be very important because, of course, the court will make directions as to time, and that can therefore be important in terms of ensuring that you're complying with a court order, because the court will sanction you for failing to comply with court orders, of course, potentially. Definitions regarding periods of time. They begin from a specified day. Well, it does not include that day. If it's to begin after a specified day, it does not include that day. And if it's expressed to end before a specified day, it does not include that day. So it's important to have regard to the Acts Interpretation Act to double check the date that something might be due on. One that's very important is this idea of may, shall, must, these different general words that are used throughout statutory instruments, or statutory throughout legislation, I should say, and how those words will have impact. So may indicates that the power may be exercised or not exercised at discretion, and usually it's the discretion of the executive. Must, the power is required to be exercised, and it only applies to things which happened, applies to acts passed after 1 January 1992, despite anything that might be done by judges otherwise, despite any presumption or rule of interpretation. So we have this mandatory concept in terms of must, as opposed to discretionary in terms of may. And there's a case example given here, which is a CLR, Commonwealth Law Reports, so it's a High Court decision from 1998. 1998, volume 194, Commonwealth Law Reports at page 355, which is the first page of that decision. Commencement dates. There are various generic provisions which deal with the commencement dates for new legislation. It used to be the case that an act potentially came into force on the date that it was taken to the governor for royal assent, or on the date that the governor signed it in Executive Council. That is the meeting between the ministers and the governor for the purpose of signing acts into law. But now often it's the case that different pieces of legislation come into force on a date promulgated either in the Act or by the Act or by Gazette. Here are some examples. Queensland, an Act might come into force on the actual day of assent. New South Wales, the Act might come into force 28 days from the date of assent. Tasmania, an Act might come into force 14 days from the date of assent. And obviously it's up to Parliament to determine that. Those might be the general rules, but they might be changed over time. Amendment. Where an Act is amended, as in the previous example, always look for that phrase unless otherwise provided in the Act. Sometimes the legislation which amends the original Act will automatically be repealed the day after the amendments commence. Thankfully, in Queensland, we tend to amend the original Act and then reprint the whole Act. So there's not such a problem whereby we have to look at the amending Act, look at the original Act, and then look at the new Act. We just get a new copy of that Act and it's reprinted in totality, and we can make reference to that. In the Commonwealth sphere, it hasn't always been as simple as that, in the sense that we may need to look at the amending Act, the original Act, and the new Act, depending on when the Acts were passed, and that certainly was the case in the past. In Queensland, we have this Section 21, continuance of repealed provisions. If an Act repeals some or all of the provisions of an Act and enacts new provisions in substitution for the repealed provisions continue in force until the new provisions commence. So a new Act is passed and it says it will come into force on the 1st of December 2013. Right up until the 1st of December, so the end of November, midnight on the end of November, the previous Act will still be in force, and then the new Act will start in effect. And that might be quite significant for a whole range of reasons. So, and there, as it says there have been a lot of cases about the applicability of amendments which might tend to prejudice a person's position, particularly in that criminal context where it might be relevant as to the question of imprisonment or incarceration, etc. So the presumption is that the legislature intends that both provisions provisions will continue to operate right up until the new provisions take effect. This is often particularly significant in circumstances where something is going on, case is going on, and while the case is going on, that case is dealing with old legislation, new legislation passes. And often it's said that, well, surely the court should be looking to the new legislation to answer the question. But in fact, the court must focus upon the legislation that was applicable at the point in time when the facts occurred. There's a very broad rule against retrospective effect of legislation. There are two cases you can both have a look at. They're High Court cases. You can see the first one, Sarawasati, and, so the V is pronounced and, R is R for Regina, meaning the Crown, which is the short form for the Crown. So that's a criminal case, 1991, volume 172, Commonwealth Law Reports at page 1. So it's the first page in that volume of the High Court reports as such. And Maxwell and Murphy, 1957, volume 96, Commonwealth Law Reports at 261. So they're two cases that are worth having a look at. If you get the CLR version of them, they have the head note, the summary at the start of the case, which will give you a good heads up as to the relevant facts, the relevant legal issues that were involved in the cases, and what happened. And that head note might only be a page or two long, rather than having to read the whole of both of the cases. Of course, Parliament, and particularly this is particularly relevant in the Queensland context, because in Queensland, with a unicameral system, the executive control the legislature, and there is the sovereignty of Parliament, so Parliament can go back and change the legislation as it wishes, to repeal old legislation, to pass new legislation. But of course, Parliament can't bind itself, so it could decide something today, and then in 6 months or a year from now, it can go back and change what it decided today. And generally, there'll be no retrospectivity in the legislation. That's the general rule. There have been things that have been retrospective, but generally that will be the rule. Section 7 of the Acts Interpretation Act Commonwealth uses this phrase, unless the contrary intention appears. Effect of repeal or amendment of an act is the section heading. No revival or other act or part. The repeal of an act or of a part of an act that repealed an act or part of an act does not revive the old act or old part unless the express provision is made. So if we play with if Parliament changes part of an act, they're not saying they want the old part to be revived. They're just saying they might delete that part completely. Maybe it will revert to judge-made law and there won't be any statutory provision applicable in the circumstances at all. And that's what this paragraph is saying right here. This phrase sunset clause, it's not a phrase you'll see necessarily in the legislation, but it's a phrase that the textbook or textbooks, the academics who've written the textbooks will tend to use as to legislation. What they're talking about is that it's the type of provision which you see used with special or emergency powers, or maybe the provision only has a period of time in which it is in effect and then it will lapse. That is the sunset. Legislation obviously is changing all the time, and it's not frozen in time as such. Obviously there are very old acts, but it tends to be a dynamic environment now, and you need to be very, very careful when you are dealing with a set of factual circumstances that you're picking up the relevant legislative provisions that are applicable. And that can be that's not an easy task in itself because there's so much legislation out there. Invalidity is a very difficult area. I did a case a few years ago called Haskins and the Commonwealth of Australia. Haskins was a member of the Navy, and he had been charged and then convicted by the Australian Military Court. And after his conviction, he then served a period in a military detention facility. I didn't act for him at all on the discipline side of things in the military context. But later on, the High Court of Australia said that the Australian Military Court was unconstitutional, that it was not a court that was set up in a correct constitutional way under the different pieces of legislation. Haskins then, by a case stated, and the Commonwealth agreed, it was a consent position, that is, the Commonwealth and the sailor, Haskins, or by his legal representatives, agreed that the question was an important constitutional question worthy of going to the High Court. And the question for the High Court was, if Haskins was punished by a court which was unconstitutional and punished in such a way that his liberty was taken away from him, that is, that he was detained, I think, for 41 days in a military detention centre, was that correct legally? And might that result in him being falsely imprisoned because the court that imprisoned him? Another example might be a person who thought genuinely that they were a police officer. For whatever reason, administratively, they had been terminated from their service as a police officer. But everybody, including that individual person, thought they were a police officer. They were going about their business as a police officer, and they arrested someone. Is the arrest invalid because the police officer wasn't a police officer? And so invalidity is not an easy question. In Haskins, the Commonwealth said, well, it's okay because subsequently the Commonwealth Parliament passed legislation which made the punishments by the unconstitutional Australian Military Court valid. They validated the punishments by the invalid Constitutional Court. And the question was the validity or otherwise of that legislation. One of the 7 judges of the High Court said Mr. Haskins was right, and the other 6 said that the Commonwealth was right. So it's an interesting point, and it's not an easy solution sometimes. I think they use examples of the work choices legislation here, where it was challenged in the High Court, and you might recall that the challenge was the High Court found in favour of the Commonwealth on that question as well. There's an example here, Roach and the Electoral Commissioner, 2007, volume 233, Commonwealth Law Reports at 162. It's just another example. And you could look at the work choices case, you could look at that Haskins case that I was in. So we've looked at this concept of the sovereignty of the interpretation legislation, particularly over case law made by judges, and how the statutory interpretation legislation is particularly relevant. We've also looked at some of the principal legislation which has been enacted throughout Australia to make legislative drafting clearer, and we looked, of course, at that Queensland statute, the Legislative Standards Act 1992 Queensland. On Thursday evening, we will have a Zoom session where we will discuss the review questions and any other matters that are of relevance to you.